Hello, everybody. How you doing? Hi, Gloria. How you doing? So, going live today for this is gonna be a short live, really, but I'm gonna kind of go start from somewhere where I left off in the motion, or not the motion, but the state's response to Avery's appeal. I'm gonna cover a couple of things and talk about a few other things and that stuff, and then I'm gonna probably get on to doing some work because I got a lot of editing that I got to do for some of the things coming up this weekend for the rally, the virtual rally, justice rally that's going to be going on this weekend. For those of you who may not heard about it, we are going to be doing a 15-hour event this weekend. It consists of a 5-hour leg with being hosted by Mark Hodnott in Australia, and then it has another 5-hour leg in the UK. And then from there, from the UK, which will be on Jane Sharp, Sharper Than a Pencil's channel, and it'll be 5 hours on the UK leg, and then it'll be 5 hours on the US leg of it. So it'll be 15 hours total. The US leg will start out on Linda Kay's Listenings channel. So there's a lot of that going on. I'm editing some things and getting some things ready for that. So I'm pretty busy. So I got a lot of things to do. Plus, folks, I am very much I'm very much now digging in with gusto into the Daniel Holtzclaw case. It's a bad one, but that's been keeping me kind of busy too. So, and then today actually was kind of funny because I can't even show it to you guys now because, well, I got blocked on Twitter. I got blocked by somebody. It was pretty funny actually. So what had happened is I was getting off of work, so I opened up Twitter, and just so happened right at the top of my tweets was Amanda Knox had retweeted this other person's tweet, and she had basically said that, well, first of all, let me tell you, this person was spitting just vitriol, just like it was bad. This person was just talking about, Amanda Knox is now advocating for Daniel Holtzclaw, who raped, 13 women and blah, 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 right? When, 5 of those women were not believed by the jury, but this person doesn't take that into account. It's so this person was just, and then they went on to talk about Patrick Lumumba and were criticizing Amanda about, the fact that, the police had, there in Italy had, kind of bullied her, and to the point where she did say Patrick's name because they kept showing her the text from Patrick Lumumba and all that. Anyway, so I responded to the person, and I just basically said, it wasn't even mean. I didn't say anything bad. I just basically said, maybe you should try to do some research, because in the future, the Holtzclaw investigation is going to be in textbooks as an example of what not to do in an investigation. And then I said, in the Lumumba, the whole Lumumba thing was a result of again, investigators with tunnel vision and bullying. And so the person responded to me by saying something like, get your trash out of here, or get your trash out of my space, or something like that, which to me is a weird thing to say on Twitter. Don't you think? Twitter's a public zone. You're going to run into people that feel the way you do, and you're going to run into people that don't feel the way you do. You kind of got to be a grown-up, right? I don't know. Anyways, so after I sent along my most recent Daniel Holtzclaw video. And so they were coming back with, get out of here, this trash. And next thing I know, the tweet was deleted. The tweet was gone. So this person had blocked me. So I was just like, okay, well, there you go. What are you going to do? It was just a bizarre thing. So yeah, I got blocked today. I feel like I did my good deed. You know what I mean? No. I didn't say anything mean to this person. I was not, I did not attack them. I suggested that they might want to do some research. Am I attacking them by suggesting that they might want to do some research? I don't think so. You know? So, all right, let's take a look at the comments before we get going. Hi, TTM fangirl. Hey, Cherie. Carrie Smith. Hello, Asharya. Oh, hey, Andrew. What's up, buddy? All right, so, all right. I don't know if you guys, I mean, you guys have probably been listening to all kinds of coverage about the state's response, right? I know Millbilly's been doing coverage. Foul Play, well, Foul Play had their part 3 today, I think, or something like that. You know, I've done 2 previous videos about it. Tracy over Scales of Justice has done 1 video. 80 More Things actually went live on their YouTube channel and did a review. I mean, so we've talked about this quite a bit, and you guys know that obviously the big themes that are coming up is procedural bar and, you know, and just like continuously procedural bar and insufficiently pled. Those two, you know, phrases get thrown around a lot. Well, the other one thing that I think is interesting is the whole thing about the preservation order, and that that you would think that because there was an order to allow testing, that would mean that there would be some allowance to get access to it, because Zellner wasn't granted access to everything right away. They allowed her to have some things, but she wanted other things, but they wouldn't let her. But she wanted other things. You know what I mean? So she took what she could get at the time. Right? And so if you're going to be handing it out like that, if you as the state are going to use that method of handing it out, you are setting yourself up for a piecemeal appeal. You're setting yourself up for it. So crying foul and whining about it, especially the way that the state's choosing to, I mean, first of all, there's all the BS with the bones where they were clearly trying to hide what they were doing. Then there's the CD, which they didn't hand over before Avery's 97-406. No, they waited until Judge Sukowicz suddenly kiboshed it and denied it, and then suddenly they handed over the CD. It's the state. The state is actually actively causing this appeal to be piecemeal. And they're whining, acting like it's Zellner. You know? It's bizarre. It wasn't Yard Dog Sapper. This was somebody else. It was obviously this was somebody who doesn't like Amanda Knox. Because like I said, it was directed at Amanda. And me, because I'm, you know, studying the Daniel Holtzclaw case right now, I wanted to get in there and say something for Daniel, you know, and this person, I mean, I totally did not expect this person, after one comment, which wasn't really that bad, to block me. I was just like, oh, wow, that's pretty sensitive. That's really sensitive. Hi, Marianne Delaney. So this part here that they you know talk about here is that they're basically saying that no matter what, Avery hasn't forfeited his argument about the 2007 preservation order, and they're basically arguing that he never argued that the preservation order gave him any right to, or it gave him any, you know, or was a cause for him to be bringing his appeal piecemeal. It wasn't Harry Ragg. No, it was Dr. Assat or some, or no, Assat or something. Assat, ASAT, Dr. Assat. I mean, after getting blocked like that and everything, I immediately thought Dr. Asshat, but no, Dr. Assat, ASAT. So that it was at Dr. Assat, you know. So anyway. The argument they made about the CD would only be upheld in Wisconsin. Well, that may be. I mean, who knows? I mean, we're going to keep plugging away at it. And I know Sapper's usually here, and he's He's the realistic kind of viewpoint, and I don't fault him for it. He's a realistic viewpoint. He knows that the state of Wisconsin is going to want to cover its butt here, and he's right. But hopefully, with enough of us getting out there and getting vocal about this and creating more awareness of these topics, that maybe it might start to become uncomfortable to hold with the old ways, and we might start seeing some change. Not saying it's going to happen overnight, but it's hopefully we're going to get there. But it's in Wisconsin. Yeah, this is going to be tough. It's going to be really tough. And like I said, the goal here really, if you really want, see, for me now, I've started to realize, I've started to kind of come to the realization that if I want to help Stephen and Brendan, which I do, the problem is, that people don't understand how wrongful convictions happen. A lot of people don't understand that they do happen. Even people that are aware of some wrongful convictions who, watch some documentaries on Netflix, they sometimes don't put that together, that every day in real life, things like that are happening. Like it doesn't compute, right? It's important to start to see how wrongful convictions happen. And that's why I've been preaching lately about multiple cases and getting into looking into more and more wrongful convictions, because the more that our community can argue wrongful convictions, and we can talk about what happens in wrongful convictions, and we can point out parallels when we're criticizing a wrongful conviction, and we can point out parallels with other wrongful convictions. This is a powerful thing. But beyond that is when we start to create this chatter about more and more wrongful convictions, that people start like walking into the conversation and going, oh, wow, and start actually paying attention. And more people will start to realize these things do happen. I mean, I remind you guys of Ricky Kidd's words. You heard Ricky Kidd himself. He told you when he was arrested for the crime that he was wrongfully convicted for, he didn't believe wrongful convictions happened. He knew he was innocent, and so he figured it was all going to work out. No matter, it just wasn't on his radar that he could be wrongfully convicted. And a lot of people are that way. It's one of the things we need to do as we're fighting for Avery Dassey is we need to start making awareness of wrongful convictions as a whole. So it's one of the things I've been talking about recently. It's something that I think is really important. And so just wanted to say that. All right. So what they're talking about here is obviously that Zellner made an argument that the preservation order that was put in place by Judge Willis is kind of, it basically, it's causing this appeal to be piecemeal because she can't get the evidence. She couldn't get the bones. So what did she find? She found that the state was trying to hide what they did with the bones. Oh, there we go. Okay. So that's why her appeal is coming piecemeal. It's like acting like it's Zellner's fault is, for me, stupid. It's not Zellner's fault it's coming piecemeal. Anyways, I don't even understand the argument they made. It was work product for the prosecution using specific guidelines. That is absolutely product that should have been in discovery. I agree, Sapercock. I mean, I totally agree with that. I believe anything that the prosecution, any expert that the prosecution hires to help in their case, that information should be shared. There should be that's it. That work product should be shared. Because most of the time, 95% of the time, defendants don't have the resources of the state, and they can't just go out and hire these experts. So for the playing field to be level, it's important that our courts start to require that the state has to share that kind of stuff, and that there's no excuse for not sharing it. I mean, that needs to be done. That's one thing that needs to happen. it's certainly one thing that needs to happen. Avery has no chance with the Wisconsin courts. I hate to say, and I understand people that feel that way. Everywhere else, to clear Brady. When they block you, then you have a valid point, and then they don't want to face. I know that's the way I basically took it. I was just like, oh, okay, yeah. You were worried that I might actually have something, of value or something, of substance to say, and you blocked me. Yeah, I agree. It even happens in Australia. No one is immune. Let's see. So, all right. So, so this thing goes on, and that's what they're arguing. That the argument that the preservation order is, because of the way that that's being executed, it was forcing her to bring it piecemeal, and the fact that she's basically just trying to say that if you're going to hand out the evidence, I mean, basically, here's the point: if you're going to hand out the evidence with an eyedropper, then you better be expecting a piecemeal appeal. Hand it all over so that you can get the 17406 motion that you're looking for. You hand it all over. You don't do it with an eyedropper. I mean, anyway. So, no matter what was agreed by the parties about scheduling forensic testing, particularly at the September 2017 meeting, it doesn't explain why Avery filed an incomplete motion in June 2017 and never alerted the court that he planned to supplement it. Wisconsin, she wanted more evidence from the start. No, was there any question of this? I don't think there was. Wisconsin Statute 97406 states that there is no statute of limitations for bringing a Section 97406 motion. As the circuit court aptly observed, Avery has never offered any reason why he filed his June 2017 motion at all if he had further investigation he wanted to complete, or why he waited months to even think about alerting the court that he planned to supplement it, and then still didn't notify the court until after he received an adverse ruling. Indeed, Avery still has offered nothing in this regard. See, this ignores the fact that Zellner wanted to test more things from the start and was denied many things. So it's, to me, this is a stupid argument, because look, that motion, and they call it the incomplete motion and all that kind of stuff. But remember, folks, that was the 1,200 page motion. That thing was huge. Okay, she took less time on that than she took on any of the smaller things that followed it. Much smaller things that followed it. I don't know. Yeah, it seems to me that when Zellner sent the letter over to Judge Sukowitz, I've done a video about it where she was telling the judge a bunch of things and letting her know about some things about how some things were getting filed. I believe there was a matter of some things couldn't be filed electronically and so had to be couriered there or something. It was just like there was, she was explaining a bunch of stuff like this to Judge Sukowitz. And in that letter, she actually mentions the fact that she was talking with Thomas Fallon and stuff, and they were arranging to do more evidence testing, okay, and everything. So to me, it's odd because within 2 days of Judge Sukowitz getting that letter, she makes the quickest decision she made on any of the appeals. You know what I mean? I mean, that's just like, am I supposed to believe that's coincidence? That's coincidence? You know, within 2 days of that letter, the appeal gets shut down with less consideration time for it than, yeah, anyway. Still trying to figure out why they assigned a doe-eyed greenhorn lawyer to this case. That's basically a screw you to the defense and the courts. The state are playing a wasting time game, and anything that can benefit Stephen is either lost, destroyed, or Sherry has, right? I had my first negative encounter on Twitter. You just ignored it. Yeah, I have no problem when people want to say something, on publicly, that has no substance, but they want to fire off their opinion like they're all self-righteous and that they don't need to fact check at all. Oh, well, I feel it's my duty to try to educate those people, right? I mean, what am I doing here? If I'm not trying to educate people and with what I've learned, then what the fuck am I doing? Right? But no, I understand. I ignore a lot of stuff too. I let a lot of stuff roll off my back because, it's better to just do that. But I don't know. I was pretty proud of myself today that I got blocked. So anyway. The brief read like it was written by a 9-year-old. Running scared. I bet the Rav is long gone. Even if Bobby and Scott were to come clean, this ridiculous judge still wouldn't listen to this case. Maybe not, but she will if the Court of Appeals forces her or sends it to another judge, either one. So I'm thirsty, folks. Hold on a second. All right. It's certain peeps, you just don't get them started as you've seen them go mental. Yeah, I know what you mean. But, yeah, I do. I know what you mean. And like I said, I do let a lot of stuff roll off my back rather than engage because certain things just aren't worth engaging about. But when I saw what that person was saying and everything, I figured that was a good opportunity, perfect place to try to create some awareness for Daniel. Since somebody was there claiming he was so guilty, I wanted to have one of my videos there for people to look at, some of the aspects of just how guilty Daniel is, and how stupid the investigation is. So, because that's what we were talking about on Twitter, folks. That was about the Daniel Holtzclaw case, just so you understand, separate from the Avery, the state's, response in Avery here. 2 different cases, but so everybody doesn't get confused. All right. So the state is now responsible for Avery's unilateral decision to file an incomplete motion and presume the court would not decide it while he conducted further investigation. That choice and its consequences rest solely with him. The circuit court properly exercises discretion, blah, blah, blah. Okay. Then the state says the 2017 preservation order does not give Avery a license to pursue available claims piecemeal. Well, it may not give him the right, but the thing that's causing my whole thing with this is that what's causing this to come in piecemeal, as you guys have heard me say already, is the state's conduct. What the state is doing is causing this to come in piecemeal, and it's just absolutely just mind-blowing to sit here and watch the state argue that this is Zellner's doing. This is like this is a conscious effort by Zellner to be bringing all these things piecemeal. Like she didn't intend to make an agreement with Fallon and everything and get more testing done. They were going to bring the RAV4 down to Calumet, okay? And then suddenly Within a day or two, before Fallon can get the RAV4 down to Calumet, suddenly, boom, motion gets denied suddenly. And then, like I said, then we have the state suddenly popping up going, oh, here, we have this CD. One second, folks. There we go. So the state's like, oh, here, we have this CD. It was in Tom Fassbender's personal custody for 12 years. What? Who? What? So, yeah, it's bizarre. So, it's truly bizarre. I mean, it's the state causing it. The state, like I said, nobody twisted the state's arm and made them give bones back to the hall box and hide what they were doing and not turn the investigation reports and the ledgers over to Stephen Avery's counsel at the time, his appeal counsel at the time. They didn't do that. They chose to try to hide what they had done. Okay? And Zellner found out. Even though they won't let her at the evidence, Zellner found out. Whose fault is it that this is coming in piecemeal? Again, whose fault is it that this is coming in piecemeal? So, hi, Sharon. My trusty Ouija in the house. How you doing? And, so it's just, I mean, this is, for me, all this stuff is just BS. I mean, it's just stupid. They talk about the legal standards and standard review for motions or for reconsideration. I mean, it's like the whole point, folks, is that in order to make wrong, and well, let me put it this way, in order to get the correction of wrongful convictions, in order to get the time down on it, we got to start. This is what we need to create awareness of. This is exactly what we need to create awareness of and make people see how flipping difficult the states make it. Just how extremely, extremely difficult the states make it for you to bring claims to try to prove your innocence. They have all kinds of laws written in to try to block and prevent any attempts to right wrongful convictions. Okay? It's not good. It's not good. Let's see. Avery insufficiently pled Brady claims of the Ramlow, or the Heidel and Ramlow. I mean, like I said, it's all insufficiently pled or procedural bar, and all those types of things, and not looking at all at their conduct, They talk about this fifth collateral attack post-conviction motion. And I think it's, I don't know. Maybe it's just bold for these lawyers of the state to be arguing that way, because obviously the Court of Appeals obviously remanded two things back, So I think arguing that way with that kind of a, high and mighty attitude, considering that two things were remanded back, I don't know. I think that could backfire on the state there. Possibly. Could. I believe Flowers was tipped off to what was about to happen with her. Oh, she was. She totally was, Sapper. 2 days before she denied it, Zellner sent her a letter. Now, it wasn't a legal motion, which would have, if it would have been a legal motion saying she was going to do more testing, that would be different. But she had sent a letter to Judge Sukowitz, and she had put in just a little thing about the fact that she was talking to Thomas Fallon and they were arranging for more testing. that they were still working it out and whatever. And that's verified because she Fallon basically was, going to try and get the RAV4 down to Calumet and all that. And he told Zellner he would notify the court as soon as they got the RAV4 down to Calumet. So that's, that's reality. Anyways, my point is that she did know. She knew from a letter that Zellner sent 2 days or just a couple days before she denied the motion. So she absolutely knew. There's no question of that. Well, she's already had a lot of words before, so they keep the reply short, usually, generally speaking. So, I believe a little birdie gave her the scoop on how bad it would be. That's very well could be. Absolutely. It could be that Tom Fallon called her and said, "Oh, shoot, you should, I don't know if we want this." And, it could be. Maybe. I don't have proof of it, but, I would say it's not out of the realm of possibility. That's what I would say. Yeah, Tom Fallon. Yep, absolutely. He probably did. He probably did go over and talk to her, or maybe he did. I don't know. But the point is that we don't need to guess at whether or not Thomas Fallon told Judge Flowers, because we know Zellner did. So we don't even have to speculate about whether or not Fallon said something, because we know Zellner did. So that's where that's at. Anyway, so it's like I say. Here it's the circuit court properly exercises discretion when it denied without a hearing Avery's July 18th motion regarding Detective Veely's compilation of items copied from the Dassey computer. Now, you guys all know how the argument goes there. The state is basically saying that, well, the CD, everything that was on the CD was on the 7 DVDs that were the entire contents of the Dassey computer. Okay, and so the state is making the argument that Avery's attorneys had access to it, and so therefore it's their own negligence or whatever, or their own fault that they didn't find that or whatever. And that's stupid. In so many ways, that's stupid. Number one, just as you're getting close to trial, and by the time they were in December, everybody knew it was coming soon. They just didn't know exactly what date, but they all knew, and it ended up being early February, right? So you wait until the 11th hour, basically, and so you dump a whole boatload of information on Dean and Jerry, literally 2 months, little under 2 months before trial. And they're supposed to be able to go through all of that when the state had to hire a computer forensic analyst, but yet the state expects that Dean and Jerry would have been able to do it. Stupid. It's a stupid argument. It's absolutely lame. And we know that the Wisconsin Supreme Court recently made a decision, or made a decision there that kind of turned around the way they look at Brady. It's no longer about defense due diligence and whether or not the defense could have found it if they had managed to look in just the right place, right? It's now about if the prosecution had it and didn't share it, Brady. It's becoming more just that simple. So exactly. They had it in April, right? They had this Detective Viele CD and the DVDs. They had all this stuff in April. That's when Detective Feely finished his analysis. So in April, they had all these things. April goes into May. May goes into June. June goes into July. July goes into August. August goes into September. September goes into October. October goes into November. November goes into December. And then they decide, oh, here's the 7 DVDs. Right? And then one tiny little report buried in a stack of reports from DCI. And on one page in that one report, Tom Fassbender refers to the existence of the Viele CD. I mean, this is obvious. This is an obvious attempt by the state to try to float this over to the net, to basically have handed it over in the way they did so that it was impossible for the Avery's defense team to analyze it, but so that they did just enough so that the courts wouldn't balk at it. That's what it looks like to me. Like they were making a very conscious effort to make that happen. And I think any human being with common sense will see that. Let's see. So perhaps, let me see. So perhaps recognizing that he cannot make a credible claim that the state suppressed evidence that he had in his possession 2 months before trial. Okay, so that's referring to the 7 DVDs, not the CD. And that his attorneys discussed with the prosecution. No, there was a stipulation to something called Brendan Dassey's computer. There was a stipulation, but it wasn't Brendan Dassey's computer. The way that the state misrepresented everything here, it's very obvious. And because of the way they did it, it's allowing them to argue it this way, which I think is BS. What's up, Henbury? Avery pivots to alleging that though he had the evidence in his possession, he did not have it in time to effectively identify a motive in the Denny motion, filed on January 8th of 2007, and alleges that the state deliberately misled him about the contents of the hard drive. Both contentions are unsupported. Oh, are they? Unsupported, would we? So, yeah, it's absolutely stupid. The state sent Avery the 7 DVDs and Fassbender's report explaining what was found on them on December 14th of 2006, listing DCI, narrative report, blah, 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 blah. 32. 32. And that was, that was 7 weeks before trial and nearly 4 weeks before Avery filed his Denny motion. It took Viele only 16 days to perform his examination of the hard drive. That's somebody who is a forensic analyst, a computer forensic analyst. It took somebody who does this every day and does this like riding a bike. It took that person 16 days. Do you think Dean and Jerry had 16 days to spare? Do you think it would have taken Dean and Jerry 16 days, seeing as they've never used this before, don't know what they're doing, don't have the experience that Detective Viele has? Do you think they would have gotten it done in 16 days? Hell no. Hell freaking no. They wouldn't have. And so, yeah, just more disingenuous arguments from the state. It's just bull. So, these guys just, moreover, Avery has again failed to establish that the contents of the Viele CD were material. No, absolutely not. All those images that Bobby pulled off of women with their heads cut off and all that kind of stuff, that means nothing. towards possibly raising Bobby as a, to the level of being a Denny suspect, and taking away the prosecution's star witness, who is the one placing Teresa at the scene and claiming that she's walking towards Avery's door. So, I mean, immaterial? You kidding me? It's just stupid. Avery claims that the pornography and violent images and search terms would have impeached Bobby Dassey's credibility, but he fails to explain how. Oh, because the jury was already tripping out. They already had issues with Bobby. If you recall, they asked for Bobby's entire testimony. All they asked for was Bobby's, but they wanted all of Bobby's testimony in court. They wanted to be able to review it. I guarantee you they weren't asking for that because they thought he was very convincing. That's not why they were asking for that. They were asking for that because they obviously had concerns and issues and questions about things that he had said. So if you're asking me, state of Wisconsin, that, it's stupid. This is really just ridiculous. It would have absolutely impeached Bobby's credibility. Okay? The jury was already questioning it. And that's why they were asking for his testimony. But that's another funny part about this case. Judge Willis denied the jury. He denied him. He denied the jury. And then he sent I guess he asked for the jury or the jurors to be more specific or whatever. And I guess after he had denied them the first time, they were just like, screw it. They were just like, this is a waste of time. And they didn't bother asking. I mean, they could have asked, I guess, for smaller portions of Bobby's testimony. But once they asked for what they wanted and then they were denied. And so they were basically like, oh, okay, fine, whatever. We won't waste our time asking this asshole. This is the jury. They're trying to make a decision. And you don't want to let them review the testimony of the state's star witness? Yeah. Anyways. Let's see here. Nor did Avery offer anything that would establish a direct connection to the crime. Well, the whole thing is that Judge Willis had determined that Bobby didn't meet the motive prong of Denny. And that's what the computer images and everything on the computer, that's what that gives. It shows Bobby had an interest in that kind of subject matter. So instead, Avery just proclaims that if he established motive for Bobby Dassey, he would prevail on Denny. Well, we'll have to see how that comes out. But as far as I can tell, they only needed one more for Bobby, and that was motive. So, all right. Let's see. Finally, there is no cumulative effect of the Brady violations because Avery did not establish any Brady violations. Yep. Let's see. The circuit court properly exercises discretion in denying Avery's March 2019 motion without a hearing. The bones. Avery's claim is procedurally barred because he has not established a sufficient reason for not bringing his claim in any of his prior post-conviction motions. Does everybody remember how this started? How many out there remember how this started? This started back at the end of 2018. Kathleen Zellner filed a motion saying because of a new type of test for DNA testing that was being used in the California wildfires to identify victims from the California wildfires. And so therefore it's capable of getting a DNA profile from charred bones and stuff, right? So then she filed a motion because she wanted to test the bones. All the bones that she listed and stuff were all bones that the state had given back. Okay? The state wasn't admitting that. Remember? The state had always been telling her they had the bones. They'd been telling her all along they had them. Okay? But they didn't. Right? So the way it went is, she was asking to test those bones. Okay? That's when we all read that motion. A couple members of the wrecking crew picked up on that. Obviously, Allie had done a live a month previous where she had pointed out that this page in Queso where they talk about giving bones back to the hall box. And so what happened is we realized that on page 1114 of Queso, they are talking about all these bones that they've given back and all the item numbers, and all the item numbers matched the item numbers that Zellner was asking for. And so we were able to put that together, and we did a live here on my channel with Travis and I believe Allie. I think Allie was with us on that one. And that was huge, right? So now because we all had the documents, because we had crowdsourced the documents, and we had all of them, right? We had pages 1114, 1115 and stuff, because we got all of it from the court. Okay? But what the trick here is the state had never sent over those pages or the ledgers. They had never sent those over to Stephen's appellate lawyer when they were doing all this. Okay, so this is all cloak and dagger. They're trying to do this under the table. This is all very dishonest. Extremely, extremely dishonest. So that's what's important here. The state's trying to act like, oh, no big deal. But no, big deal. Even you knew it was a big deal because you were trying to fucking hide it, you assholes. Yeah, anyways, so let's see. The cops will have told Bobby he is going to prison if he don't implicate Stephen. Simple as that. I believe there was a lot of intimidation going on during this investigation. And so, yeah, you may very well be right, Kevin. Let's see. Also, KZ Expert said that the computer was wiped again back in 2012 and 2013. Yep. The cops will have told about, yeah. I don't understand why there's one interview sealed. Can you explain why this happens? One interview that's sealed. I don't know what you're referring to, Cindy. There was a CD that was sealed, but Zellner, when she went to open that, there was nothing there. And that's supposed to be the zipper CD. I don't know if that's what you meant. If that's what you're talking about. Let's see. Smoke and mirrors. Amisa. You're asking me, isn't that Brady? What specifically are you asking me about? If that's Brady? Hi, drama must remain on the stage. Hello, Caper Bye. Hey, Crockett. The stuff on the computer constitutes a number of felonies at the federal level. Right. Yeah. That's true. I mean, what was on that computer was pretty disturbing. See, rapid DNA technology that Leo are now using as well. Yeah, that's the testing that Zellner wanted to use to test the bones, the Andy rapid DNA testing, which was being used here in California during the wildfires in 2018 to identify bodies. To be I don't know about any sealed parts of the interview. I know that there's days that they didn't record, like nothing at Fox Hills. I know that, but it's not lost. It never existed. They didn't record what they were doing at Fox Hills because they didn't want anybody to know what they were doing. So that they said they sent the bones and docs, but didn't. No, they never said they sent them. They just didn't send them. No. So okay, let's go ahead and let me re-explain. I'm not saying I'm not I'm not saying that they said they sent or that I'm not saying that they said they sent anything. They didn't want to mention what they were doing with the bones. They did not want to say a word. They didn't want to raise anybody's suspicion as to what they were doing. They certainly didn't ask anybody if they could hold back paperwork. If they had asked if they could hold back paperwork, it wouldn't have worked. The paperwork would have been asked for immediately. And so you got to understand what they were doing was hiding it so people couldn't see it. Okay? So what they did was when they created these documents, it became part of the court's file, right? But Stephen Avery's file, the file that came to Zellner when she took over the case, okay, the whole file was assembled. It took a long time. We waited almost 3 months, I think it was, while the file was being assembled. And somehow these pages didn't get in there. Yeah. No, I'm serious. I'm not kidding. We were waiting like 3 months. I kept making the joke. It was my first year supporting. And I just on Facebook, I just kept making the joke every time the compiling of the record came up. I'm like, yeah, I got a feeling there's a big, huge bonfire in Wisconsin somewhere, and that's why it's taking so long and they can't find everything because there's a big bonfire and agents of the state are throwing stuff on it. But seriously, no, yeah, there was a compiling of the record, and somehow this stuff never made it in there. So you got to understand what they did at the time is they created these reports and they created these ledgers. And all they did was file it in the court's copy. They did not bother to share it with Stephen at all. They did not mention it to Stephen. They did not say a word to him or his appellate attorney at the time. See, that's them hiding what they were doing. They knew it was wrong and they were trying to hide what they had done. Erekose, I've heard there were drugs related somewhere in this case, but I've also heard no. Do you have any idea if anyone was dealing or doing? I don't know specifically if anybody was doing any drugs. I don't know that anybody was dealing them. I could not say that with any kind of certainty at all. So, I don't know. I really don't. I mean, it seems I can't speak for everybody because I don't know. I haven't heard, but I don't know. Maybe I don't know. There's a lot of. It seems like marijuana is fairly popular in Wisconsin, even though it's illegal as all hell. But anyway, I don't know though. As far as I know, I've never heard of anybody dealing. I do remember there was a story circulating, but I've never seen any kind of substantiation for it, and so I don't really ever talk about it anymore. And there was this rumor going around about Ryan and Bobby, like Ryan was dealing, or maybe Bobby was, or something. There was all this whole thing for a while, but there was never any substance to back it up. So if there's no substance to back it up, it's like, no, I don't know. So as far as I know, there's not any drug dealing or anything going on. Okay, so there's Sapper talking to you about the whole thing about, He's basically like well, here, you just look at the difference in the way that Sapper and I choose to word things. I basically said, I have never found any substance to any of those claims, and so therefore I can't believe them. And then Sapper has his own way of saying it, but I don't know which one I like better, but either one works. Barb was supposedly arrested for possession right around the 30th. Oh, that's right. They did. Yeah, she got popped for possession of marijuana, or something. Yeah, I do recall. But then again, I really don't kind of count marijuana. You know, it kind of needs to be cocaine or meth or something serious for me to really, it's just weed. No, that is true. She was. They did pull her in for something regarding weed. I'm pretty sure. I remember that. No, wasn't asking if cops involved with those two. Yes, Barb. But I heard meth. I don't know. I have absolutely zero confirmation of that. And I'm certainly not going to go around spreading it. I have no confirmation of that. So, like I said, I've heard about Wisconsinites liking their marijuana and their weed. But yeah, I don't know. I mean, I imagine there's some of the harder stuff there, but it's serious business, man. You get serious jail time just for little minor offenses in Wisconsin. So could be the harder stuff. People just stay the hell away from it because they don't want to get in trouble. I don't know. But then again, maybe there's a lot of people doing that stuff. I didn't see it. I saw some people smoking weed, but I didn't ever see anybody, chalking up lines or anything like that. So. Who was the witness who gave a recorded statement that later died? That was the one that was that's the one that is sealed. Oh, okay. Barb's arrest was most likely to avoid the Avery salvage yard, any Averys or Dassies. Yeah, they were trying to control things. They were trying to keep people separated, and they were playing all kinds of games with people's lives. I mean, it's absolutely just ridiculous. Whew. All right, folks. Well, we're getting to around an hour, and I do actually have some other work I got to get to here. I got some other things I need to edit for Rally this weekend, so that we can keep you guys all entertained during the 15 hours, right? So we have some things that we've made to kind of fill in some things and in some just to make it more fun and everything. So, but I got to do some editing on those things so that they'll be ready for this weekend. So I'm going to go ahead and start winding it down now. Thank you everybody for being here and everything, and talking about obviously Avery Dassey and talking about the state's response here and talking a little more about it. Has the boyfriend ever been a suspect? The boyfriend was never, if you're talking about Ryan Hillegas was never seriously considered as a suspect by the investigators. By the defense, yes. By 99.9% of the people that watch Making a Murderer, yes. But for some reason, not the investigators in this case. So, go figure. So, everybody get geared up for Rally, the online Rally event this weekend. I hope to see many of you there. It's going to be a lot of fun. And I like getting together with the community and seeing everybody come together and just see everybody talking in the chat and the live chats and everybody, mixing it up. And I love that. I just love it. That's one of the best things about Mammothon is just watching all you guys out there as you're, getting all, worked up and you're, getting excited and passionate and stuff over in the live chat. Dig seeing that. So hope we're going to see a lot of you guys this weekend and for the rally event. It's going to be, hopefully a really, really good time. Like I said, we're working on some special stuff, and it should be fun. Where's Ripper? Do you mean on YouTube, or do you mean like he was on my channel 2 nights ago? I don't know. Are you asking where he is physically on the planet? I just need a little bit of direction there, and as to what you're asking. I guess if I go with where is he geographically, he is in Florida. How's that? Oh, he's talking to Carol Baskin right now? All right, folks, that's it. I'm ending this live now. See you later. I want to go check out Johnny talking to Carol Baskin. Bye, guys. If you haven't already, please hit subscribe.